In this lesson, we're going to take an introduction to the equitable doctrine of promissory estoppel, one of the most important elements of contract law and one of the most important elements of the creation of a contract. So, this is the final couple of lessons that we're going to do on the creation of contracts. So far, we've talked about agreement, which is represented as the offer on the one hand and the acceptance of the offer on the other. We then spoke about the idea of an intention to create legal relations, and then finally I spent the last few lessons talking about consideration. This lesson is going to consider promissory estoppel in a little bit of detail. We'll talk about the case which establishes this rule of promissory estoppel, before in the next lesson talking in more detail about what promissory estoppel actually implies and what it does, and give some more case law illustrations of how promissory estoppel works. So, what is promissory estoppel and how does it work? Well, it's an equitable doctrine, as I noted previously, and what it does is provide exception to the requirement of consideration for the creation of a contract. There are certain rare circumstances where a contract can be created without the prerequisite consideration, owing to the equitable doctrine of promissory estoppel. So it sort of is about the idea of consideration, and this all comes down to the reneging of a promise and how equity steps in certain circumstances to remedy circumstances in which an individual has reneged on a promise. A party may be prevented or stopped from reneging on a promise that had been made prior in certain circumstances owing to the intervention of equity, which is what promissory estoppel simply means, the prevention from reneging on a promise. So estoppel means to prevent, fundamentally, to stop somebody, and the promissory element relates to the reneging of a promise, promissory estoppel. It comes all from the case of Central London Property Trust versus High Tree House Limited from 1947. Specifically, it comes out of Lord Denning's obiter in this case. So we will talk about this as we go through the case, look at the facts of the case, and look at what the obiter actually suggests. So, the case from 1947, Central London Property Trust versus High Trees House Limited. In this case, High Trees House Limited had leased a block of flats prior to the beginning of the Second World War. In the UK, the Second World War began in 1939, and they had began leasing flats to the property since 1937. So they had done this, they leased a block of flats prior to the start of World War II. The flats were leased at an original £2,500 per year. That was the original rate, which of course is quite a significant amount of money, even in today's standards. Not necessarily per year, but at least at the time it was quite a significant amount of money. In January 1940, it was agreed between the parties to reduce the rent to £1,250 per year, half the rent, owing to the lowering of occupancy rates. Obviously, this was due to the impact of the war, people going off to war, people going and moving around the country in different ways, and so there was a major demographic shift in the whole country as a result of the Second World War. While there was an agreement to reduce the rent, there was no conclusion as to the duration at which the rent would remain reduced. This would obviously make sense, given the fact that the motivation for the reduction in rent was the war, and nobody knew in January 1940 how long the war would last for. The lower rent would continue to be enforced until the occupancy rates began to pick up, which obviously takes place back in 1945 when the war ends. So there was a period of time during the war where there was a lower occupancy rate. They agreed in January 1940 to lower that occupancy, to lower the rent, shall they say, for by half to £1,250, and there was no agreement as to how long this lowered rate would continue, and it would continue, as it turns out, until around 1945, when the rates would continue, when the rates would increase as a result of the increase in occupancies. Litigation began when the owner of the flats, Central London Property Trust, sought to recover the full rent from the period of July 1945 onwards. And it was held by Lord Denning that the promise to waive certain rights, i.e. not having to pay as much money owing to the lower occupancy rates, was done on the basis of there being a lack of occupancy. It was done for a reason. It was done for a lack of occupancy, which was caused by the Second World War. As soon as the occupancy issue had been resolved, i.e. when more people began to fill the properties back up in mid-1945, the claimants would be able to claim for the full price of the rent. The only reason why there was a lower there was a lower rate of pay for rent was because of the lack of occupancy. So when this condition is resolved, then this full price of rent should go back up. But it was also suggested by Lord Denning in his obiter that the promise which the defendants had relied upon was the reduced rent at the time of the lower occupancy. And this means that if they tried to recover the full price during this period, they'd be stopped from doing so. So if they had said in this case, when they wanted to sue High Trees House Limited, that they had gone, well, we actually want the full rate of rent for the entirety of the period, all the way from January 1940, all the way through the Second World War and then past to 1947, then they would be stopped from doing so, because the reason why this promise was in place in the first place was because of the reduced rent at the time of lower occupancy. And so this gives the rule of promissory estoppel. They are stopped from doing so as a result of the fact that they had made a promise, and they cannot renege on that promise, which is what they would have been doing in equity as a result of this particular element. Now, the next lesson is going to talk about this case, this issue, should I say, this idea of promissory estoppel in more detail, and we'll talk about how it is applied into more case law as well.